Welcome to this meeting of the Harriman Institute's series of workshops and panels on human rights. We have tonight the authors of several of the best new works, books, and articles on the subject of transitional justice. Their common theme is justice and politics. So back in the early 1990s, advocacy of criminal accountability for atrocities stressed morality and law and was extremely successful in calling attention to the problem, mobilizing outrage among the public, and energizing activists to work on this issue. There were also claims made for the practical, beneficial political consequences of putting perpetrators on trial. Justice, it was claimed, would deter future atrocities, would strengthen the rule of law and democracy, and therefore pursuing justice through trials would strengthen peace. But at that stage, I think it's fair to say that the political consequences and strategies of justice were not the central message at that time. But since that time, there's been tremendous success in mobilizing energies on this issue. And there's been the creation of the International Criminal Court, among other organizational successes of this advocacy movement. And so I think recently it's fair to say that the debate has been moving more towards focusing on the politics of justice, and particularly on what are the consequences for politics of transitional justice efforts. And that's exactly what our panelists have been writing about in their books and articles. They've been looking at such topics as how does the political setting, especially the power and interests of key players, affect the kind of justice process that emerges, if any. They've been writing about what role does the threat of legal accountability play in bargaining with powerful perpetrators, and what role is it appropriate for that kind of bargaining to play. And they've been writing about what are the consequences of trials for the rule of law and democracy. So before I introduce our panelists, I'm going to ask my colleague Alex Cooley to give you a bit of an advertisement about a couple of seminars and workshops that we're going to have coming up in the next couple of weeks in this series.
Okay. No, just very briefly, as part of the cluster of our events, next week we will have a panel on the politics of international media rankings that will feature Lee Becker, represented from Freedom House, Carleen Kerlacher, and Ann Nelson. And the week after, we will have a panel on the politics of illicit indicators and the contestation of numbers. And that will feature Peter Andreas of Brown University, author of a new book, and Lara Nettelfield, again, also Sally Mary of NYU, and Patrick Ball of the Benetech Corporation. So please join us over the next couple of weeks where, again, we will try bring together scholars with practitioners for a productive dialogue on these issues. Thanks.
Thanks, Alex. So tonight for our panel on transitional justice, we have 4 authors of recent research-based works and 2 distinguished panelists. Our authors begin with Ruti Teitel, who's the Ernst Stiefel Professor of Comparative Law and Associate Director of the Center for International Law at New York Law School and visiting professor at LSE. Ruti is, as I understand it, the person who's actually coined the term transitional justice, which was the title of her Oxford University Press book on this subject back in 2000. And tonight she'll also be drawing on her forthcoming book, Humanities Law. After we hear from Ruti, we'll hear from Professor Leslie Vinjamuri at the University of London School of Oriental and African Studies. She's the author of a number of articles on transitional justice in international security and ethics in international affairs and other journals, and she's writing a book on transitional justice. Then we'll hear from Professor Monika Nalepa at Notre Dame University. She's the author of Skeletons in the Closet, which is a book about transitional justice in Eastern Europe. And that'll be the basis for her talk tonight. After Monika, we'll hear from Lara Nettelfield, who's a postdoctoral fellow at the Harriman Institute this year, associated with our Human Rights Project. And she's the author of Courting Democracy in Bosnia and Herzegovina, the Hague Tribunal's Impact in a Post-War State, 2010 from Cambridge University Press. Right there, a book that Richard Goldstone has praised highly in his blurb. So those are our four presenters of their research. We have two distinguished commentators. Tina Rosenberg is the winner of the 1995 National Book Award for her book, The Haunted Land, Facing Europe's Ghosts After Communism. And she's also about to publish a new book, which I will plug. It's called Join the Club, How Peer Pressure Can Transform the World. Our other discussant tonight is Aryeh Neier, who's the founder of Human Rights Watch and is currently the president of the Open Society Institute. So, Ruti, please start us off.
Thanks, Jack. It's great to be here with this panel and so many friends and colleagues in the audience. So in my remarks, is this on? Yeah. I'm going to pick up with where my book left off. As you may recall, and the book is 2000, but it really took me longer to produce than Tina's book on Eastern Europe and Latin America. It's a comparative study of transitions at the time. And what I want to talk about is how the framing of transitional justice has changed from that period to the moment, present moment, and in particular the role of human rights and the subject of the human. And I'm going to talk about these remarks in light of a question and pose it in terms of a question, and that is transitional justice a human right? Has it become a human right? Question mark. So at the time that we were all, many of us on this panel, debating these issues, I remember a debate with Diane Ortlicker at the Council on Foreign Relations in 1990 about a debate about whether Latin America could become a democracy, several countries that were undergoing transition, Chile, Argentina, without trials, whether it was possible to have true democratization and stability without trials. And in particular, this seemed to be clearly happening in Chile, and then later we would see Uruguay and even Argentina, starting with trials, would abandon them. And in that time, the conceptualization of transitional justice seemed to be around a series of dilemmas and local decision-making. And we thought about that as informed by domestic law to some extent, but really political questions for political actors in those countries. What would Alfonsine do? What would Elouine do? What would the local judiciary do? What would the legislators do? And so this was the kind of, and the dilemmas were framed as peace versus justice, sometimes truth versus justice, often suggesting that there were Hobbesian choices and one value would have to yield to another. In the current moment, and again, this is a snapshot. I spent a lot of the last 48 hours thinking about the transitions in the Middle East, and perhaps this will come up in the Q&A. At the present moment, this entire way of thinking about it as a discretionary matter for local decision makers seems to have really fallen away. And so that's what interests me, is the change in the narrative. And in particular, I'm going to draw on three sources of illustrations of this area of law that is in to some extent both constraining actors but also shaping their own discourse and enabling other sets of choices on the ground. Three sources. One is from the region of Europe, the other the Americas, and thirdly international law, the World Court and the ICC. And I know that other speakers will get into this as well, so this is really a very general. And that is, we might think about two recent cases that came before the European Court of Human Rights. And intriguingly, they relate to the subject at hand, the post-communist moment, the Balkans conflict. And in two recent cases, January 2011, and you can imagine it's a long time since the Latin American transitions, but it's also decades since those conflicts. 1991 war crimes, where the European Court of Human Rights held that the investigations by the Croatian police and judicial system were inadequate. And these were cases involving Croatian nationals of Serbian origin who had been taken away in Vukovar, and there were, of course, conflicts over the control of that land. They were accused of terrorism, and very little information given. This is the Lara case and Skenjic case. What's interesting is these cases come to the attention of the world through petitioners, through the families, right? The human subject. They are claiming rights that relate to the rights to life in the European Convention. And what's interesting is that, well, the life is gone, right? These are disappearances for the most part. And the court says that there are related rights that even decades later pertain to the right to life, to the presumed loss of life. And they conclude that these rights mean that the state has a general duty to secure everyone within their jurisdiction, so of whatever nationality, of whatever ethnicity, rights to an effective official investigation. As we'll see, this idea is not at all radical. It had been ruled on in the late 1980s, and I'm going to get into that in Latin America. There were cases holding that there was a right to an official investigation. What does effective mean? What does official mean? What does investigation mean? And what we'll see is that there are a number of different bodies that are ruling on these questions. The court says that official and effective means that it can't be the police that took them away, and it can't even necessarily be the local units where the disappearance occurred, but that the idea of an effective investigation means an independent investigation. And as we know, even in our more established system, often independence can mean a change of fora, some guarantee of impartiality, and here they said it meant a judicial investigation. So you have a regional system, a regional judiciary ordering an investigation, and they said that it needs to be prompt and independent. They go on to hold that there are other rights that pertain, and in particular, a ruling that it's borderline torture, inhuman treatment, to have spent decades not knowing where your family was. And this is very interesting, and also entails families to reparations. Now, these cases are just the most recent and the most dramatic because they are, less than a month ago. The European Court built on prior jurisprudence coming out of Cyprus, the Turkish-Cyprus conflict, prior disappearances, prior cases defining what is torture. So it's a very interesting body of jurisprudence that's coming out of the European Court of Human Rights. Now, they built on the Inter-American Court, and so what's interesting here is, from a legal perspective, is that they're not compelled, they're not bound by the rulings or the precedents of this other region, and yet the rulings in that region inform the European Court of Human Rights decisions, and they specifically, in some of these cases, cite cases coming out of massacres in Peru and disappearances in Honduras. The landmark case in the Inter-American Court since the late 1980s holding that there is a right of investigation, and this has been now touted as a right to truth by victims groups. It came out of Honduras, disappearances in Honduras, the famous Velázquez-Rodriguez case. And here it's a very interesting question, because the court says that it's really a principle of international law that is read into the regional system, and that the principle of international law, the regional law requires a right to life under the American Convention, but the body of international law says that wherever there's a violation of an obligation, there's a duty to investigate and make adequate reparation. So the courts are themselves engaging in cross-judging, if you will, pulling together, looking at different legal materials that relate to these violations, and ruling often against the local, national systems, political and legal judicial actors, ruling that they have rights and that these rights need to be honored. In subsequent cases that have been noted in the press more generally, there are at least 3 countries where the Inter-American Court has ruled that their amnesty laws are no longer viable. Certainly, most recently, Brazil, and before that, regarding Argentina. And these cases, as you can see, take us farther down the road in terms of judicial activism, right? Because we're not just talking about a right to truth and investigation. We're talking about a court saying that beyond the duties to investigate, there are, that in overturning the self-amnesties, for example, in Brazil and in Argentina, that there were attendant duties of independent prosecution. And this, of course, will lead us in a moment to the last organ that's functioning today with an impact on local decision-making, and that is the International Criminal Court. And here we, many of us have been very interested in the last decade at the ICC. And what we see is that the court has taken very seriously its jurisdiction as complementary to national criminal jurisdiction. The jurisdiction at the ICC, according to its preamble in Article 1, is complementary to the national criminal courts. And what that means so far is unclear, but what it means in terms of the operation of the court is that the court essentially is reviewing the actions of national bodies. I'm going to move along. Obviously, there are human rights implications. As we know, the Security Council in a high-profile case referred Bashir and Darfur to the court, and that's an instance where it could certainly have implications for peace negotiations on the ground, and I know that other panelists will get into this. What I want to end with, since there are a lot of other illustrations, and I'm happy to get into this in Q&A, is how might this encounter with transitional justice affect the framing of the questions, right? We certainly can see that the courts are taking interest in the nature of the duties and rights owed to victims groups and the duties that states have. The duties of states, according to these decisions, extend beyond the state actors to non-state actors. So we're talking about paramilitary. We're talking about wherever there are actions that are imputed to the state and beyond. So it's a very wide-ranging role for the law. One way to think about it is that the law here is kind of part of the shadow or the environment in which political decisions get made. And so part of what we'll get into, I assume, in the Q&A is how these legal developments, the gap-filling functions of the law, where there have been human rights claims made that pertain to transitional justice, are reshaping the decision-making and dilemmas as they're perceived by political actors. But I just want to end with a question, which is, even if it is now legally a human right, what is the legitimacy of this development? In instances like Uganda, Sudan, and Lebanon, and perhaps Mubarak today in Egypt, how do these new duties and rights that are being articulated by legal bodies, how are these shaping the decision-making on the ground? How are they affecting the permissible trade-offs? Who should decide? And what is the legitimacy of this evolution of transitional justice?
Thank you, Jean. Next, we have Leslie Moore.
Thanks, Jack, and thanks for having me. I want to pick up on some of the themes that that Jack mentioned, and also Ruti, and speak about this move towards really looking at impact, which of course is central within human rights, but I want to look specifically at transitional justice. And in particular, I want to look at this in the context of discussions, advocacy, and also scholarship about the impact of transitional justice, or the move by tribunals and courts to indict and to engage in situations of ongoing conflict. So let me say a few things about why I think we've seen this shift, and what I think, I take this to be one of the most crucial changes, and I also take it to be potentially one of the most dangerous areas for transitional justice to go. And along these lines, I'm going to also share a few findings that I've come up with through my research that cast some doubt on some of the arguments that are articulated by advocates, and some of the arguments that are also being made by academics about this. So the name of the game is impact, and of course this is a topic that takes place among, I would say, three communities. Identify three communities: funders, advocates, and scholars. And I'm really going to talk about the last two, although clearly the discussions amongst funders are central and are driving a lot of what's happening at the level of advocacy. We convened a meeting in London a few weeks ago amongst human rights funders, and as one of the leading funders there said, the name of whom I won't mention, actually an American funder who came over, which was the cause of the meeting, said, why should human rights get a pass? And this person was, in a sense, articulating what he saw to be, would be a shift in the criteria that would really drive programming in the area of human rights and justice. And this was really the theme of the meeting, and the meeting was very interesting because there still was some debate, and this is a theme that I'd like to articulate, which is I think that the public discourse on impact is much less nuanced than what I think is happening, and I'm sure all of you know that better than I do, than what's actually happening behind closed doors. I know that the president of ICTJ is here tonight, David Tolbert, and when he was at our launch of the London Transitional Justice Network, I think the quote, if I'm wrong, please correct me later on, whether we like it or not, the name of the game is impact. That's where we are. And then that was on the record. So it's clearly there, and as Ruti said, and as Jack also mentioned, the arguments and the language used to be very, very different. I always think of Diane Orentliker's piece named The Duty to Prosecute, and I think in that piece she was talking primarily about a legal duty, but clearly we know that human rights in general, and I would argue also transitional justice, has been thought about historically as being something that's sacred, that it's a protected space, that it's the right thing to do. And I think especially when we begin to look at the new advocacy that surrounds interventions in ongoing conflict, that message, at the least at the level of the publicly articulated message, has really very much been lost. And there's been a triumphalism about consequences. Why is this? I would just flag three things very quickly. One is that many of the institutions, especially the ICTY at the moment when it was engaging in Bosnia and indicting Milosevic in Kosovo, was still a very new institution. It was created in the middle of an ongoing conflict, so ergo here we are. And in order to actually justify one's role, I think, in the time of ongoing conflict, it becomes very difficult to talk about things other than impact. And impact in these situations, I think, has become narrowed to be about arguments on behalf of the role of transitional justice in bringing and delivering peace and deterring future conflict. So it's really deterrence and peace that I think has been narrowed in on. What's the problem? The stakes are extraordinarily high when we're talking about ongoing conflict. The expectations when advocacy takes this line, I think, become increasingly high, and in a sense that's a problem that is constructed in part by advocacy. And the evidence doesn't seem to justify the articulated arguments. So let me show you just a few slides that what I've done in my research is to put together a data set that looks specifically at international justice in cases of war and post-war, so conflict and post-conflict situations. I'm not looking at all transitions. And I put this up here for two reasons. I should say that in general, my orientation towards research is not quantitative. I'm deeply, deeply skeptical, and as I imagine many of you are, of quantitative research. However, the academic research on the impact of transitional justice has gone in this direction. Okay, so I think it's extraordinarily important, despite the fact that most of my work is qualitative, to begin to put this up here. So the first two slides are intended to demonstrate one thing, that the variation over time doesn't look the same as the story that we're being told, both by some scholars, Catherine Sinkink, I think most notably, but also by the general line that we read, which is that international justice is more prolific. There's a lot more going on. Now, I had breakfast this morning with Pablo, and he said, the problem with these people who talk about amnesties is that they don't separate out amnesties are not amnesties are not amnesties. So what I've tried to do is to really look at this, and it's a little bit difficult to see where you are, but if you look at the second slide, you can see that actually there are the trend in terms of the overall trend in the use of amnesties has actually accelerated. It's increased, as has the trend in every other mechanism, trials and truth commissions. But limited amnesties are also increasing. So there is something that's changing, and that's really quite significant relative to general amnesties. But the story is still very different from what we're hearing. This slide I put up because it separates out what's happening when amnesties are embraced by domestic actors and what's happening when amnesties are embraced by international actors. And here I think it's actually very significant in demonstrating what I take to be a trend, which is that there is a very big difference between the international and the local in terms of not only practice but arguably preferences. And so if you look at the green and purple lines, which are 1990 to 2007 at the top of the charts, those are domestic amnesties, both general and limited. And they're being used a lot more often than amnesties that are embraced by the international community. This slide I put up because it tells us some interesting things. Now, these are correlations, and a lot of the academic research that's being done on impact is trying to prove, which I don't personally think you can do, whether or not transitional justice contributes to sustained peace or not. So what I've done is to look at the role of trials, truth commissions, and amnesties with respect to the sustainability of peace 5 years out. And what the purple shows you are the cases in which, if you only look at the blue bars, those are the cases in which peace holds or peace fails when trials, truth, and amnesties are pursued either during conflict or within 2 years of conflict being settled. And so what we can see is that if you look at that first bar on the left, trials where peace holds for a minimum of 5 years, the total number of positive cases is 28. But it reduces to 11 when you talk about cases where trials were only 11 cases, peace was only sustained in 11 cases when you look at the timing. So in other words, delaying justice leads to a much higher correlation with sustained peace. And that's really what that's intended to show. The results don't look fantastic for amnesties, right? Amnesties where peace fails is the farthest slide on the right. And so I want to show you one more slide which is significant about this. Civil War scholars, Monika Toft in particular, have argued in much of her work that the hardest cases for sustaining peace are wars which are ended by negotiated settlements. They're twice as likely to result in the reignition of violence as wars that are ended through military victory. And if you look here where it is the amnesties are being primarily used, 71% plus the 3% in the green. So 74% of amnesties are being pursued in cases of negotiated settlements. They're being used in the most difficult circumstances. So it becomes a very, I put these up again, you may or may not have seen other research on the topic, but it becomes a very difficult debate that needs to be linked up to when you start talking about interventions in ongoing conflict. It absolutely has got to be linked up to the work that we know from scholars who have really looked at Civil War impact. So I think I will conclude there and come back to some more arguments later.
Thanks, Leslie. So next up, Monika and Nalepa.
Thanks, Jack. Thanks, everyone, for coming here. While we listen to the developments in the Middle East, many of us ask ourselves, will Mubarak ever step down? And some have compared the anti-authoritarian protests to the peaceful revolutions in East Central Europe that took place over 20 years ago. Indeed, there are some lessons we can draw from those events. One of them concerns the relationship between the possibility of peaceful transitions to democracy and transitional justice. There is a very vast literature on how the mode of transition affects the choice of transitional justice mechanisms. But much less has been said about how the anticipation of transitional justice constrains autocrats' willingness to step down from dictatorial power. And why should Mubarak peacefully step down? Over the 30 years of his dictatorial power, he's committed numerous human rights violations against his own citizens. He could face the prospect of transitional justice. In other words, he could find that upon stepping down from power and giving it up to the opposition, to the members of the opposition whom he once prosecuted, that opposition might want to settle scores with the former dictator. Scholars have pacted transitions like the ones that took place over the third wave of transitions in Latin America and fourth wave of transitions in post-communist Europe have envisioned that maybe some process of negotiations between Mubarak and the opposition could occur. And historically, these pacts have been portrayed as exchanges of free and open elections for the opposition's commitment to refrain from transitional justice or give the former dictator amnesty. But the problem with this commitment is that it's not credible. It's not credible because the opposition's delivery of the promise is temporarily removed from when the deal is struck. In other words, once the autocrats step down from power and leave office, they leave themselves at the mercy of an opposition that has incentives to renege on that earlier promise and punish the dictator for former human rights violations. So we can represent this commitment problem using a simple game theoretic model that I call the simple transitions game. In this game, we have two players. We have the autocrat, Mubarak, for instance, and we have the opposition. The autocrats can step down or not step down. If they step down, they're basically believing the opposition that it will refrain from punishing the autocrat with transitional justice. The autocrat steps down from power, and then the opposition has a choice. It can keep the promise and honor the agreement of amnesty, or it can renege on that agreement and punish the dictator with transitional justice. What's going to happen in this game depends on what the two players that we've modeled here prefer. I argue that for the autocrat, the best situation is if he steps down from power peacefully and is not prosecuted with transitional justice. If he can't have that, then he'd rather maintain the status quo. The worst outcome for a dictator like Mubarak would be if he stepped down from power and then was persecuted with transitional justice. What about the opposition? Well, for the opposition, the worst state of events is if the dictator doesn't step down and the authoritarian rule continues. The second best would be if the dictator stepped down and were not punished with transitional justice. But the best outcome for the opposition, and that's represented with the number 2, is if the opposition actually reneges on the agreement and punishes the dictator with transitional justice after he's stepped down. So what happens in this game? It's a very simple way for solving it, because we could just start from the end and ask ourselves, what would the opposition do once given a choice whether to honor the agreement or to renege on it? And clearly, since it's better off reneging than keeping the agreement, it would punish the dictator with transitional justice. Well, but then the autocrat can anticipate that if he steps down, he's going to suffer transitional justice. So in this game, if it adequately represents the rationale or the decisional calculus of dictators, dictators should not step down anticipating that they will be punished with transitional justice. So the Nash equilibrium of this game, which we have found together, is that autocrats should never step down, and we should never observe peaceful transitions. But this is not what we observe around the world. Turning back to the recent history of East Central Europe, we can actually focus on a particular example of transitional justice, of lustration. Lustration is a good example to focus on because what it does is it denies public office to members and collaborators of the former authoritarian regime. And because of that, it's a very particular instrument of retribution that can be exploited by the former opposition. Because elected positions that the former collaborators are banned from running for are easier accessible to members of the former opposition once transitional justice has been implemented. In other words, lustration eliminates political competition, and that's why it's always to the advantage of the former opposition. So let's see how countries in East Central Europe, most of whom have transitioned through peaceful means, through peaceful negotiations, fared in terms of meting out transitional justice in the form of lustration to its former autocrats, to the communists. So this table shows 10 countries in East Central Europe, all of whom, except say for Romania, transitioned exclusively peacefully. And the shaded cells show the periods during which lustration has been enforced. And we see that while some countries, such as the Czech Republic or Lithuania, immediately proceeded to punishing the former autocrats with transitional justice in the form of lustration, others, such as Poland or Hungary, actually, or Slovakia, waited sometimes even more than 10 years to implement it. Unsurprisingly also, lustration has been by far the most popular transitional justice mechanism in the post-communist region. So we see that there is a far from uniform pattern in adopting transitional justice. While some countries adopted sooner, others adopted later, nevertheless, it's almost always adopted. So we're still left with two unresolved puzzles, which I try to explain and address in my book, Skeletons in the Closet. And those puzzles are, to reiterate, why, given the choice of honoring and reneging on a promise of refraining from transitional justice, did the opposition in Eastern Europe honor its promises, such as in Poland and Hungary? And why were the autocrats not afraid that they would be punished with transitional justice, particularly in the form of lustration? And in my book, I answered these questions within the same framework in which I framed the puzzle. Social sciences, such as political science, are replete in credible commitment problems. So I'll look for solutions to the simple transitions game among the common solutions to credible commitment games. And one of these solutions has been proposed by Thomas Schelling in the form of the kidnapper's dilemma. So in the kidnapper's dilemma, the kidnapper abducts a victim and demands a ransom in order to release her. However, the problem is that if the ransom is paid out, the kidnapper still does not have an incentive to release the victim because the victim has seen him or somehow interacted with him and can then reveal this information to the police. So by releasing the victim, even after receiving the ransom, the kidnapper is worse off than by actually doing away with the victim. So the kidnapper's promise that he will release the victim upon receiving the ransom is not credible. There's a credible commitment problem in the kidnapper's dilemma. So how does Thomas Schelling propose to solve this dilemma? Well, he says, suppose that the victim were to give the kidnapper evidence of some horrible act that she has committed in the past. And then upon releasing the victim, the kidnapper would hold on to that evidence. And under the circumstance that the victim would release her information about the kidnapper's identity to the police, the kidnapper could expose the evidence against the victim. In other words, the victim, by keeping some skeletons in the kidnapper's closet, ensures the kidnapper that she will not rat out his identity to the police. So to solve the credible commitment problem in the regime transitions game, we need to find some skeletons in the opposition's closet. An intuition as to where we would find these skeletons can be provided by the following two quotes that I'll show you. The first comes from a dissident in Poland that I interviewed while researching my book. And he said, when I met Kwaśniewski was the first post-communist president, a successor communist in Poland. This was after the elections, the first free elections. He said, don't mess with those files. Let them be. The agents were mostly your own people. The next interview makes this point more explicit. It would be naive to think that transitional justice hurts only the communists. Agents were everywhere. I would expect more of them among the dissidents, because if you were to infiltrate anyone, why would the communists infiltrate themselves? They needed snitches in churches and dissident circles, not amongst themselves. That's where the collaborators are. So I argue and demonstrate in my book that the opposition's skeletons consisted of secret police collaborators among its own ranks. While members of the authoritarian regime were most eager to become collaborators of the communists, those who were most useful were the oppositionists themselves. Furthermore, the oppositionists had very strong incentives to conceal the fact of collaborating with the secret police from their fellow dissidents. So as a result, not only was the anti-communist opposition infiltrated with secret police agents, but it was also painfully unaware of the extent of this infiltration. It simply didn't know how many of its members had been recruited by the secret police. And while the easiest way to find out about the extent of infiltration would have been to implement a lustration law, it was also the most costly way of finding out. Because if the opposition had a lot of collaborators, it would suffer after the electoral consequences of having its skeletons in its closet exposed. So we can actually model the effect of this uncertainty of the opposition about the extent of its infiltration by including one parameter in the payoffs of our former simple transitional justice game. In this model, we would include an additional parameter, I, for infiltration, that can take up a value between 0 and 1, and that determines whether implementing transitional justice after the transition hurts the communists or the opposition. So while all the other relationships between the payoffs remain the same, the players still prefer transition without transitional justice to the status quo. Whether or not transitional justice is desirable depends on the value of this infiltration parameter. So if the opposition has a lot of collaborators among its ranks, it will prefer to honor their commitment. But if it's clean, then it will prefer to renege. The problem for the opposition, for its calculus, is that it does not know its infiltration. The communists, however, do. And this makes sense because the secret police was working for the communists and not for the opposition. So in this game called the signaling game, the communists act as the sender. After learning how infiltrated the opposition is, they decide whether to initiate negotiations or not. And the opposition acts as the receiver of the signal. After observing whether the communists step down or not, it decides whether to honor its agreement or not. I'll save you the trouble of solving this game, which is a little bit more involved, but the most important finding from solving it is that there exists an equilibrium called a separating equilibrium, where the autocrats will step down from power only if the opposition is sufficiently infiltrated with collaborators, or if the opposition has a sufficient number of skeletons in its closet. The opposition reads this as this action of the autocrats as a signal that it's infiltrated, and it prefers to refrain from transitional justice. It prefers to actually abide by the promise of refraining from amnesty, because it's afraid that if it embarks on an extensive transitional justice program, it will lead to uncovering collaborators among its own ranks. So in short, the skeletons in the opposition's closet have an enabling effect on peaceful transitions.
We assigned the writings of all four of our scholars to Tina to work through to be the discussant tonight. So let's see what Tina Rosenberg made out of that.
Thank you, Jack, and thank you all for coming tonight. In my defense, my book is only medium thick, certainly by the standards of the Harriman Institute. We've heard presentations from four fascinating scholars on different aspects of a subject that a couple of decades ago no one would have dreamed was a real academic discipline of transitional justice, but it seems to have become one. We've heard from Ruti Teitel about the new ways that the world is thinking about transitional justice and new ways of evaluating it. We've heard from Leslie Vinjamuri on the effects, a quantitative approach to the effects of amnesties, truth commissions, and trials on keeping the peace in countries that are attempting transitional justice either during or after conflicts. We've heard a very interesting presentation on lustration and game theory, which I will get back to, and Lara from Monika Nalepa, and Lara Nettelfield's presentation on her book, which looked at the effects of the International Criminal Tribunal for the former Yugoslavia on Bosnia, and found that, in contrast to the naysayers, it actually has a moderately positive effect, would you say? And all of this is interesting. All of this opens up vast doors to study new aspects of all of these things. But I'd like to make a couple of comments, first focusing on Monika Nalepa's research on lustration. And my comments are really, I'm not a political scientist, I'm a journalist. And so I come to things really through a different approach, much more anecdotal. But in my opinion, her analysis of the different sides in this game of lustration or not lustration leaves out a few important things that I'm sure that she will want to pay attention to in her next book on the subject. And one of those is that I think she seems to not pay attention to the fact that oppositions and ruling parties are not monoliths, they're divided. And certainly among the opposition in Poland, there was tremendous ideological division. There was a group of people who went through the various names for them. The real Poles was one name for them, who were very much always pro-lustration. There was a group of people who were never pro-lustration. For example, in 1979, Adam Michnik, who was the sort of intellectual leader of this group, wrote a very important essay called Maggots and Angels. And in that essay, it was a reply to another historian's article condemning the passivity of Polish intellectuals throughout history. Michnik went one by one through the, quote, maggots, unquote, of Poland's history, arguing that occasionally conformity was justified, at least to the point where outsiders should withhold judgment on those historical figures. Michnik's theme, the overwhelming theme of his life, his writings as a Polish dissident, was warning his fellow dissidents and fellow anti-communist activists not to fall into zealotry. In a 1985 letter from prison, he wrote, "I pray that we do not change from prisoners into prison guards." In the New Republic, he wrote about the two stages of the struggle for freedom, and wrote that the struggle for freedom is beautiful, but the second phase of revolution is not so beautiful. A psychology of vengeance and hatred develops. Michnik has spent his entire career warning against vengeance and hatred, and I think he would put lustration into that category. He had always been against it. The thing that made what he thought even more intense was a phenomenon of the Polish transition that I think also affected other transitions. And I think it's one reason we have to look at how a country arrived at a negotiated settlement, and that was the Round Table. Michnik and Kuron and and Wałęsa and the other Polish dissidents participated in talks with the ruling Communist Party, and the most intense of those took place at a small group called the Round Table. And it produced an ideology in itself, which many people in Poland condemn, that it was referred to as Round Tableism. And it created bonds between the most conciliatory in the two groups that became stronger than their bonds with their own hardliners in their own parties. And at the end of the Round Table talks, Michnik and Jaruzelski probably had more in common than Jaruzelski had with certain other real hardliners in the Communist Party. Believe it or not, Jaruzelski was not one of those people. Or Michnik had with the real Poles in the opposition. And they made agreements there that both sides later on felt that they had to live up to. So I think I'm just pointing this out to say there are other factors here that really cannot be reduced to a chart where you have yes and no in various points. And the form a pact took, the form a revolution took, Poland was a particular movement where the solidarity movement went on for years before there was a transition. The people who were against the regime were at that point fairly well known. That was not the case in Czechoslovakia, where it sort of snuck up on people all at once. And then people had to do the sorting out afterwards. All these different things affect, later on, how you make decisions about whether you have lustration or not and what form that lustration can take. Another point I want to bring up that I think is important to remember is that many of the people in the opposition would not feel a common cause with the collaborators among them. They would feel that those people had lost their, they had forfeited their membership in the ranks of the opposition. The German opposition to the Communist Party in East Germany, afterwards, many of the people that I met spent evening after evening after evening hanging out, talking about who among them was a Stasi collaborator. They did not feel affection for those people. They wanted to take them and put them in a box and dump them in the sea. They would have no problem with a lustration that uncovered collaborators within their ranks because that they felt by the act of collaboration those people no longer belonged in their ranks. I also want to talk a little bit about an aspect of thinking about transitional justice that I don't think has been mentioned tonight, but also is important when we look at what is it that we want transitional justice to do and how do we get there. And to me, one of the things that's extremely important is thinking about how you change a political culture that allowed a country to fall into dictatorship. And I find that to be a supremely important question. There are many, many different goals that one can have for transitional justice, but to me, this is an overwhelmingly important one. How do you get a country, how do you move a country from being a country where people don't think for themselves, where they accept blindly the arguments given to them by the state? They don't consider that citizens have rights, that citizens can act against the state or independent of the state. How do you move that to a country where people think of themselves as people with rights, the state having limited power, people having thoughts of their own, and not just listening to the loudspeaker? And I think it's useful to look at systematically at two different regions of the world where there has been transitional justice. And those are Latin America and the totalitarian communist regimes of Eastern Europe. The differences are important, and one can categorize them and look at what they say about what kind of transitional justice you can have and you do want. The first difference between them is that these two groups of countries, although I understand that they were in themselves very different. Chile and Guatemala were extremely different regimes. Poland and Romania were extremely different regimes, but they had basic similarities that I'm going to lump together for purposes of comparing one group, Latin Americans, with the Eastern Europeans. First of all, there was a different kind of dictatorship, authoritarian dictatorship, usually by military coup in the Latin American case, communist totalitarian dictatorship to a greater or lesser extent in the Eastern Europe or former Soviet Union case, and they had different implications. The Latin American dictatorships sought silence from their people. The Eastern Europeans sought their people's political participation, and that affects the level of societal complicity. Military dictatorships gained and held power with the complicity of a segment of society, usually the upper class in Latin America. But the abuses that Latin American dictatorships carried out were usually carried out by a very small group of people. We know who ran the Naval Mechanics School death camp in Argentina. We can name those people. We know who a lot of the torturers were. We know who ran the death squads. Victims often run into their torturers on the street in Uruguay or in Argentina. It was the average person in Latin America was not necessarily complicit in these crimes. In Eastern Europe, things were very, very different. Here, the lines of complicity for upholding the communist government were much more complicated. They ran like veins and arteries inside the human body. Even the most natural responses of self-preservation in a communist society were, in a sense, also acts of complicity with the government. For example, a journalist knows that a critical article about the government will get her fired, so she writes an uncritical article. A father worries about his son's free tongue, so he tells his son, don't complain in public about the scarcity of oranges. People are told to go to the May Day parade, so they go to the May Day parade. These are ordinary citizens doing what ordinary citizens do in a communist society, but such, quote, normal collaboration helped to keep the regime alive. Jan Urban, one of the Czech dissidents, put it very well. The question isn't what some they did in Eastern Europe. We all have to ask ourselves what we did. So that's one difference. The second difference is the nature of state crime. In Latin America, the generals crushed people with murder, torture, and disappearances. Acts of violence focused on a small group of individuals. These crimes were in fact crimes at the time of their commission. They were illegal under existing law, and they were committed by individuals whom it is possible to bring to trial, at least legally. Politically, there's other problems. In Eastern Europe, the situation was very different. For decades, Stalinism was violent on a scale unimaginable in Latin America. Eastern European regimes under Stalin were also, some of them, very violent. But after Stalin's death, with the exception of Albania, most of the regimes in Eastern Europe were keeping power not through violence, but through corruption and coercion. The secret police bureaucracies and the political commissions who took away people's passports, took away their jobs, took away their children's right to schooling, were commissions. They were not necessarily acts of individuals. They were acts of the state, groups of the state, bureaucracies, and they were not illegal. They were the very foundation of the communist system. Communist repression required a bureaucratic apparatus to run, and that requires a very different way of thinking about how you deal with it once it's gone. In short, the Latin American military dictatorships were regimes of criminals, and the Eastern European communist dictatorships were criminal regimes. A third difference is in the legacy that these two systems have left behind. In Latin America, less so now, but for many years after the military dictatorships fell, the threat of the return of the generals was very present. The civilian democratic governments could not punish the crimes of the military because the military still had a loaded gun to their heads. Democratic governments were too weak to punish their militaries. They hit on truth commissions as a second best. They were an option available in Argentina and in Chile because trials were really not politically possible. In Eastern Europe, you had a very different kind of threat. The governments there were not too weak. They were too strong. They abused their power over their people. Communism itself was shot in the heart and will not return. But the unchecked power of the government is still a threat that remains in many Eastern European and especially former Soviet countries. It left a poisonous residue. People got accustomed to seeing governments with near absolute power, to see law twisted daily to suit political ends, to see no checks on government. For someone who grew up under communism, the idea of citizen rights was a new idea. And so what you have today are governments that in some ways are still too strong in the sense that they abuse the rights of their people. That means what you're looking for in terms of transitional justice is going to be something quite different than you want to look for in Latin America. You have different threats, different levels of government power today, and different types of toxicity left in the society. All those things are things you have to think about when you decide how you are going to deal with the past. So I'll stop there and turn it back over to Jack.
Okay. Thank you very much. Listening to Tina just now, I think it was striking to see the gap between the comments of a journalist who was reporting on these matters in Latin America and for a period in Eastern Europe, and the scholarly work that is being presented here. And I think I also represent a point of view that doesn't quite mesh with the scholarly work that has been presented this evening. There's a disjunction between my experiences as someone working to try to promote human rights and dealing with efforts to use what has become called transitional justice as a way of trying to protect human rights. My own engagement with mechanisms of what we now call transitional justice started in 1983, and at that point the Argentine military, having lost a war against the British, had become discredited and had to yield power. And before yielding power, they purported to amnesty themselves for the crimes that they had committed. And that became an election issue, and the candidate who rejected the amnesty was elected. And that set in motion the current concern with what we now call transitional justice. President Alfonsine ordered a process to investigate what happened to people who disappeared during the military regime. The name Truth Commission was not used, but that became the popular name for the commission because there had been a group of mothers of the disappeared, and they wanted to know the truth about what happened to their children. And so it was popularly called a Truth Commission to meet that demand. And he also set in motion what became a justice process. The justice process was aborted along the way. There were a number of military revolts. The Argentine government put them down, but in the process, Alfonsine backed away from the justice process. His successor pardoned those who had been convicted, and other Latin American countries got the message that it was too difficult to do justice, to prosecute and punish the military officials who had been responsible for the disappearances and torture and other crimes in Argentina. And so truth commissions acquired a greater popularity. That was one of the factors that was important to me some years later at the time of the wars in the former Yugoslavia. In 1992, at Human Rights Watch, we published a report which I used the term war crimes in the title. It was the first time that I had used that in any of our reports. And we called for the establishment of what became the International Criminal Tribunal for the former Yugoslavia. There were actually three factors that influenced that call. The three factors were, first, this was July 1992. The war in Bosnia had started in April 1992. We wanted to call attention to the seriousness of the crimes that were being committed in Bosnia. And so we wanted to differentiate them from other things that we had reported upon previously. So we used the term war crimes in the title of our report, and we also called for the establishment of a war crimes tribunal. The fact that the justice process had failed in Latin America because of the lessons of Argentina was another factor, because we wanted to try to get back to the idea that trials and criminal prosecutions were an appropriate way to deal with such serious violations of human rights. And the third factor was what may seem like an obscure point of international law, but it was quite significant. The obscure point of international law was that under the Geneva Conventions, the provisions that deal with what are called grave breaches, which means war crimes, only appear in the sections that apply to international armed conflicts. They don't appear in Common Article 3 of the Geneva Conventions. They don't appear in Protocol 2 to the Geneva Conventions. And most of the conflicts that we had focused on up to that moment were internal armed conflicts. And the general understanding at that time has changed today, but the general understanding then was that the concept of war crimes only applied to international armed conflicts. But because what was going on in the former Yugoslavia was an international armed conflict, there were 3 recognized states. There was Serbia, Croatia, and Bosnia-Herzegovina. We thought the concept of war crimes did apply to that armed conflict. We wanted to highlight the international nature of the armed conflict, and therefore that was also part of the call for an international war crimes tribunal. Those were the factors that actually entered into the call. Coincidence, the report was published, and the next day a journalist named Roy Gutman published an article in New York Newsday in which he disclosed the existence of what became considered something like death camps. Omarska was one of the 2 that he reported upon. And the day that his story appeared in the newspaper, the State Department spokesman at the noon press conference was asked whether the U.S. State Department had information to confirm what appeared in Roy Gutman's story, and the State Department spokesman did confirm the Gutman report. So suddenly, everybody was aware of camps. Camps sounded like the Nazis, and so this call for a war crimes tribunal, by accident, caught on, and others picked it up. And when we articulated the rationale for the war crimes tribunal, most of the things that are mentioned as the sort of instrumental consequences, the impact that we were trying to achieve, were not what we were talking about during that period. We did not say that it would bring about peace. We did not say that it would bring about democracy. We did not say that it would bring about reconciliation. We did talk about the intrinsic significance of justice, and some of the other arguments that we made in favor of the tribunal were directly related to that. That is, we said we wanted to restore a sense of justice in places where it had been disrupted. We thought that trials reflected or would reflect respect for the victims of abuses. We said that we wanted to help survivors to resume their lives. We said we wanted to individualize criminal guilt. We did say that we wanted to interrupt cycles of revenge, and that could be seen as something related to peace. we did talk about deterrence, but we weren't ourselves very much persuaded by the concept of deterrence. In ordinary criminal cases, one thinks that the swiftness and sureness of punishment are critical to deterrence. There wasn't any way that we could imagine swift and sure punishment of those who were committing those crimes. So we were very half-hearted in talking about deterrence. And then the issue that mattered most to me in talking about the need for a tribunal was the idea of collective political responsibility for the crimes that had taken place. And I was very much influenced by the work of the German philosopher Karl Jaspers following World War II, in which he had written about the question of German guilt. Jaspers had differentiated criminal guilt, which could only be individual, and moral guilt, which could only be individual, and what he called metaphysical guilt, which could only be individual. But he said all of us collectively are politically responsible for this. That is, not just the people who actually commit the atrocities, but they commit them in a political context, and others who do not themselves commit the crimes have a political responsibility for what took place. And of course, in Germany, over a period of time, and it didn't happen until about 2 decades or so after World War II, there was an assumption of political responsibility. That is, a large number of Germans, even if they were too young to have committed crimes during World War II, even if they weren't born at that time, did come to feel a kind of collective political responsibility, and that seemed like something very important. And so those were the kinds of things that we were concerned with in calling for the establishment of the Yugoslav Tribunal. A series of sort of unanticipated developments actually led to the tribunal. I'll mention just one. I mean, the scholarly literature, I think, has a tendency to make these things look as though they follow some orderly pattern, some predetermined pattern. It didn't work that way. One of the things that happened was that James Baker became the political campaign manager for George H.W. Bush's campaign for the presidency. And so his deputy, Lawrence Eagleburger, became Secretary of State. Eagleburger had been ambassador to Yugoslavia. He spoke Serbo-Croatian. He was known as Lawrence of Yugoslavia. Eagleburger was very unhappy that he, as Secretary of State, was going to be somehow blamed for allowing this to go forward. You remember that George H.W. Bush was faced with 2 crises at that moment. One was the crisis in Somalia, the other was the crisis in ex-Yugoslavia. And Colin Powell was supposedly advised George H.W. Bush, we do deserts, we don't do mountains. And so the U.S. Went into Somalia and allowed Yugoslavia to go forward. And so Lawrence Eagleburger, no great champion of transitional justice, became a supporter, held a press conference to announce his support for the creation of the Yugoslav Tribunal, and named 10 persons, including Slobodan Milosevic, including Radovan Karadzic, including Ratko Mladic, who ought to be brought to trial before the Yugoslav, before such a tribunal, Lawrence Eagleburger put the United States on record as a supporter of the creation of the Yugoslav tribunal. And when the Clinton administration came into office, Bush having been defeated, Madeleine Albright, as the U.S. ambassador to the UN, picked up the effort that Eagleburger had launched, and she led an effort at the UN Security Council to actually establish the Yugoslav tribunal. I won't stay with the Yugoslav tribunal except to say that I actually consider it an immense success. I mean, it has held trials of people from 4 countries. That is, from Serbia, from Croatia, from Bosnia-Herzegovina, from Kosovo. The fact that it has tried people from all of the countries that were involved in the conflicts, not just from one of the countries, is an enormous contribution. They have been fair trials. Not everything was perfect about them. You know, they've lasted too long, they've been very expensive, and so on. But the fact that they were fair trials is an enormous achievement. They have apprehended all but 2 of the persons who were indicted by the prosecutor for the International Criminal Tribunal for the former Yugoslavia. They have inspired the creation of courts in Bosnia, Croatia, and Serbia that have continued the process and have prosecuted and brought to justice many of the criminals who could not be tried in The Hague by the International Criminal Tribunal for the former Yugoslavia. This is a spectacular success. If you want, from my standpoint, a significant indication of the success, which relates to the concept of collective responsibility, think of what happened in November when Boris Tadic, the president of Serbia, went to Vukovar and apologized for the massacre that took place at Vukovar, and then Ivo Josipovic, the president of Croatia, reciprocated and went to a place nearby where 18 Serbs were massacred and apologized for that massacre. The fact that the presidents of Croatia and Serbia have come forward and apologized on behalf of their countries for these crimes is an immense achievement. And from my standpoint, demonstrating that collective political responsibility is really the most significant accomplishment I can think of for the International Criminal Tribunal for the former Yugoslavia. Just a word or two on the question of lustration. Tina, I think, addressed the things that I would want to say, but she did so much better than I could. I would point out only that she mentioned Adam Mechnik, that if you think of the other great dissenters of the former Soviet bloc, if you think of Sergei Kovalyov in Russia, and if you think of Václav Havel in the Czech Republic, these are not great advocates of lustration. They, like Adam Mechnik, were very dubious about the lustration process, and many places where lustration took place, it actually didn't take place right away, and it got to be part of the political struggle in those countries. that is, political figures who saw advantages for themselves in discrediting some of their opponents, were very often the proponents of lustration. It was not entirely a debate that was focused on issues of justice. At any rate, it looks different from the standpoint of those who were engaged in these struggles. You were trying to have an impact on ongoing aspects or ongoing crimes. Or sometimes you were dealing with crimes that were past. But you were trying to have an effect, but mostly you were trying to have an effect by doing justice, not by serving other purposes. Justice is an end in itself. It's not merely a means to something else. At least from my standpoint, and different people who are active in this effort had different concerns, but at least from my standpoint, the most important instrumental purpose was trying to create that sense of collective responsibility for crimes that certain individuals committed, but they only committed with the political support of many other persons in those societies. Thank you.
Well, thanks so much for that wide-ranging set of comments. The discussants were pretty gentle, so I don't see any need to go directly back to the panel for rebuttals. If you all have things you want to say in response, I'm sure you can work it in as we do the Q&A. So in a minute, I'm going to open it up to anyone in the audience who wants to ask a question. Just line up at that mic, and we'll take your questions. While you're thinking of your good question, I have one that I want to ask on the theme of bargaining. And since Monika and Leslie are our two bargaining-oriented people, this might be for you, but it could really be for anybody on the panel. So it used to be that the people who wanted to bargain with perpetrators were skeptics of transitional justice who saw trials as a problem, getting in the way of bargaining with the bad guys to try to get them to agree to step down voluntarily in exchange for an amnesty. But what I've noticed lately is that now it's actually the transitional justice advocates that are often big proponents of bargaining. In fact, one of the claims that gets made for indictments is that either an indictment or the threat of indictment can be used as pressure on human rights violators to get them over a barrel somehow in the bargaining process. The question is exactly what's the logic through which this mechanism works? And sometimes the idea is that you threaten to indict them, but then if they step down from power, you don't follow through. This raises the questions of, well, how do you make that commitment credible? Especially in a world in which, according to international law, as I understand it right now, you can't give an amnesty for war crimes, crimes against humanity, or genocide. So you don't have any of those mechanisms to make the commitment credible. Unless you happen to have one of those convenient skeletons in the closet. Maybe the ICC has skeletons in its closet, but other mechanisms, though, seem even more convoluted, like the idea that after you've indicted someone like Bashir, if he promises to behave well for the next 12 months, you'll say, okay, we will hold the ICC off for 12 months through action of the Security Council and sort of dole out a stay of justice 12 months at a time. This seems pretty politically convoluted. So I don't know, I'm wondering to anyone in the panel whether they think that there actually are credible, effective ways to use either indictment or threat of indictment as a bargaining tool, or whether this is an idea that just doesn't hold water.
Well, look, bargaining is very much part of the criminal justice process in the United States. That is, plea bargaining takes place all the time. The American criminal justice system, such as it is, would break down completely in the absence of plea bargaining. I don't think that you can expect that kind of plea bargaining in the international justice field when it involves high-level perpetrators. Outside the United States, plea bargaining isn't a comparably recognized phenomenon, and you would get significant resistance to it from non-American participants in the process, and it's hard for me to imagine it in the case of a Bashir. I can't imagine that Luis Moreno Ocampo would engage in it. Political figures might try to engage in something like that, but not the prosecutor directly. Radovan Karadzic says that Richard Holbrooke promised him that he would not be tried if X, Y, and Z took place. I don't know what Holbrooke said to Karadzic. I don't rule out the possibility that that Holbrooke did offer Karadzic an opportunity to get off, but it wasn't something done in conjunction with Richard Goldstone at that time. It would have been entirely separate, so it would have been a political effort, but not a prosecutorial effort.
Monica?
I would actually say that issuing an indictment by the ICC comes quite close to plea bargaining in the international context. This goes back to a conversation I had over lunch with Craig Furman, one of the students here at Columbia, who said that a very small percentage of potential indictees actually do get indicted by the ICC. But issuing such an indictment against a certain perpetrator changes his or her expectations about how likely he is to be the next one persecuted. So it actually alters a lot of the decision calculus that these individuals go through in a way that I would say is quite similar to plea bargaining or other bargaining in justice context. And also the ICTY did plea bargain with at least some of the perpetrators in former Yugoslavia, and I think that
but with low-level people.
Right, to get to the big fish that the lower-level people had information about. So one could make the argument that it can also be used instrumentally in the context of international justice.
Leslie?
Yeah, I don't think it works, and the reason that I don't think it works is because what we know from scholars of international security and from practitioners of international security is that for instruments of coercive diplomacy to work, that is, whether you're using economic sanctions, military force, whatever it is, and in this case international justice, when you're talking about ongoing conflict, for these instruments to have an effect on the decisions that their targets, the war criminals in this case, make, they have to be contingent. There has to be the credible belief on the part of the person who's being indicted that if they change their behavior, that instrument, the force of that instrument will be altered. And the law is not built to work in that way. So I don't think when you start to use the law as an instrument for affecting peace, and to quote Ocampo, who said to a group of us at Oxford in, I think it was 2009, law is a tool for restraining violence. So despite where it started, I think that there's been quite a high level of articulation of the goals being about restraining violence, about peace, and about deterrence. Although I fully understand the mixed and the very different and more fundamental beliefs that started this out. Although I will say, with all due respect, my first thoughts on this being about deterrence came when I listened to you speak at a conference at Bard College in 1998, when you talked quite a lot about the deterrent effect that the ICTY had from Bosnia to Kosovo.
No, it did. That wasn't one of our goals, but what in fact happened, if you looked closely at the crimes that were committed in Kosovo, they were essentially not the crimes that were the subjects of the indictments for what had taken place in Bosnia and Croatia. They were different kinds of crimes. There was no counterpart to the siege of Sarajevo. There were no camps in the Kosovo situation. There wasn't anything like the Srebrenica massacre. There were some small-scale massacres that took place in Kosovo, and my view of those massacres had been that they weren't necessarily centrally directed. They were instances in which the KLA had ambushed Serbian troops, and then a local commander thought that the KLA who were involved came from a particular village and committed a massacre, a small-scale massacre, at that village, rather than a sort of centrally directed effort. And so I think, in fact, even though terrible, horrendous things happened in Kosovo, maybe 10,000 people were killed in Kosovo, the actual crimes committed were not the crimes that had become the subjects of indictments in Bosnia and Croatia. They were different, and there was, in fact, a deterrent impact. But that wasn't what we imagined when we called for the creation of the International Criminal Tribunal for the former Yugoslavia. We didn't know that it could get to that point.
Please.
Hi, my name is Laurel Fletcher, and I just wanted to thank all of the panelists. I think this is a great discussion. And so my question is sort of a reaction, and then really a thought question for all of you or anyone who wants to answer. And my question is really sort of, so Ruti, you started us off talking about the normative developments, legal normative developments around transitional justice and how courts are thinking about that. And I thought it was actually that Aryeh, you had a nice bookend to that, which is bringing us back to law as law and law as justice, and calling for justice sometimes is all that it's about, and that's all that, I thought you gave a very strong justification for why sometimes that's all it needs to be about, and isn't that enough? And I thought, Leslie, that your slides, and I saw your discomfort in talking about the numbers, but knowing that you had to talk about the numbers and the impact ties in, I think, to this larger debate. When we think about that the politics, and we talk about the politics of transitional justice, then what is it that we were actually trying to measure, which goes back to the goals? So my question really is, so how should we be thinking about justice in transitions? And it strikes me that if we want law to act as law in restraining violence, and yet we seem to be most comfortable, and maybe it's most effective after the transition. And that when law, it becomes a tool of politics during conflict, and trying to, whether law becomes a bargaining chip to negotiate a transition, that's when it felt like the panelists were very uncomfortable about law acting as law, because in fact it wasn't. It was a proxy for politics. So my question is really, is part of the problem that we're using law to both act as law, and we're using law to act as politics. And we need to be thinking more concretely about the phases in which we actually want law to act as law, and the phases in which we're using law to act as politics. And if that's true, would just invite your reflections about what that means for the research and the questions we should be asking, that scholars should be asking, and how it should inform policymakers and advocates in the moments, because they're always advocating in the moment of conflict. And I think today's headlines about Egypt is one example of that.
So, anybody want to answer how to sequence transition and justice?
That's a big one. I don't know if, do you want to go on to the sequence? So why don't you go first?
My work that I was presenting here is all pitched at saying, wait, because if the goal is as Aryeh and Neier has suggested, which is it's really fundamentally about collective responsibility, about individual responsibility, about guilt and innocence, then I don't understand why logically it's necessary to pursue that goal prior to the resolution of conflict. If it's about something else, then we're in a very different game. And what I was trying to show is that if it's about something else, it's not working very well, right? So all the evidence and all the arguments suggest to me that it's the wrong domain to be in. So I'm very, that's in a sense an answer to your question, I hope. But.
Ruti?
Yeah, I guess where I come in on this is that just picking up on what Leslie said, yes, there's more scholarship now, but a lot of us were there at the beginning. Aryeh, and I'm Argentine by birth and was a citizen of Argentina at the time that I started my interest in some of these questions. So, and I don't distinguish as crisply between what happened in Latin America and Eastern Europe, and partly because of the role of the U.S. and the broader geopolitical support of certain groups that were in opposition to what was called communist guerrilla that were opposing white Christian values in Latin America, and certain other groups that were doing the same in South Africa. And I don't see it as a kind of a messianic moment that brought all of those transitions to come to light, but rather really serious geopolitical changes that happen. And then the question becomes what to do in the periphery, right? Who's the we that decides that there's going to be a tribunal in one place and lustration in another? So I'm very interested in the discourse that's used in the panel and by scholars and journalists and those in the region. Now, one thing that was interesting is that I think everyone on the panel agreed, even though there's wide disagreement on the panel, on the notion that using the word crime matters. So Tina referred to a country where there are criminals versus a criminal regime, and Aryeh referred to the importance for Human Rights Watch of talking about war crimes. And certainly the NGOs, one of the big changes in the discussion of transitional justice is the globalization of it, the advent of NGOs and other actors that are busy mobilizing for different institutions and using a certain language. And that shift from a political language to the language of war crimes and the law of war, it creates a different space. It's a different, and it relates to the use of transitional justice now when there isn't an end, right? Where the peace hasn't arrived and it's in the midst of conflict. So what we're seeing is that I think this really affects the kind of empirical and normative work, because there are a lot of different values and goals on the table, right? I mean, there are people who say, well, does it work? According to what? Like, what is the purpose? And, I do think, and I differ with Aryeh on this, that the stated goal of the ICTY, according to the Security Council, its Chapter 7 powers, was peacemaking, because that is the power that the Security Council had to create a tribunal. Otherwise, the Security Council is not in the business of creating tribunals, and it was explicitly the only power that was related to the tribunal. They said that for peacemaking purposes, a court would, and then they went, that it would achieve this through reconciliation, through Goldstone gave a very big speech in the beginning of his prosecutorial work, saying that it was important to have indictees from every one of the different ethnic nationalities, which is a form of affirmative action in criminal law, because the idea was that this would play some role towards the peace. So my concern is that there are a lot of different values. It gets back to your concern about the sacred, but that justice seems like outside of this picture, and that there's a discomfort and I think anxiety among several folks, here and elsewhere about this idea of bringing in a language of political bargains, that they're competing values. They just, their concern is that that's not the language of justice. So, there's a lot to say. These are just some thoughts following up on the talks and some of the questions.
So I had told our panelists that we would be ending around 7:30, but I think we can take one more question unless people need to rush. So please.
Thank you. I've been following the events in Tunisia, Egypt, and other North African and Middle Eastern countries. Oh, I'm sorry. Yeah, my name's Amy Fass. I'm not really affiliated any place. And I heard someone say that that this could be make a comparison to 1989 and the fall of communism, and I'm wondering, Aryeh Neier spoke about applying the experience in Argentina to Yugoslavia, post-Yugoslavia, and I'm wondering if how the experience, the post-communist experience in Eastern Europe might be applied to the events happening today.
I don't know. No, look, I think that it's very difficult to foretell how these things will evolve. In the Egypt case, I'm very skeptical that Mubarak is worried about the possibility of being put on trial. Mubarak, before he was president of Egypt, and before he was vice president under Sadat, was the commander of the Air Force in Egypt. He has retained his strong military connections. Whatever regime comes into being in Egypt, the military is going to be a decisive force in Egypt. When he appointed Suleiman as his vice president, it seemed to me that he was signaling to the military that his son was no longer in the picture, and that he was going to a leader of the military as the person who he wanted as his successor. And so it's extremely difficult for me to imagine that whatever might take place in Egypt, that there will be a trial that might involve Mubarak. Whether there could be a truth commission is a different question. I also think it's a different question as to whether there might be some prosecutions, depending on how things evolve, of the police who took off their uniforms to beat up and in some cases kill the demonstrators in Tahrir Square. So I can imagine something like that in Egypt. I can't imagine Mubarak being put on trial. I don't know enough about Tunisia to really have any sense of how things will evolve. What little I do know is that there was great popular hatred for the wife of Ben Ali and for members of her family for their very significant involvement in corruption. And if I were imagining whether there would be trials in Tunisia, I would guess that corruption would be the most significant focus of any trials that take place. But it's not a country I know about, and you have to, have a sense of the circumstances in that country to be able even to speculate about how things might evolve.
Well, thanks so much to our panelists, our discussants, and our excellent audience.